The recent Texas law, SB 8, has been described as an attack on the right to abortion. The case challenging the law, Whole Women's Health versus Austin Reeve Jackson, has been a lightning rod for abortion activists. Referring to the law as both extreme and blatant violation of the constitutional rights, President Biden has been one of the chief spokesmen opposing this law and the decision by the Supreme Court. Now, by going to the original documents, we can cut through the hype and understand the truth, not only about the law, but the court's opinion as well. So we'll do that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. We do that by going to original documents and original sources to see what really happened and what the law really means, which is what we're going to do in just a few minutes here today. And if you want to find out more, head to the website, constitutionstudy.com. That's where you can find out all about the work that I'm doing. You can find my articles, my videos. You can join my live Q&A. It's all available there on that website, constitutionstudy.com. Now, there's a lot more you can do to help, and I'll talk about that at the end of the video. But for now, let's talk about this Texas SB 8 law. So we'll start with the Texas law itself, and this is at the heart of the current debate. Now, there are three interesting provisions in this law. First, Section 171.204, prohibited abortion of unborn child with detectable fetal heartbeat. Except as provided by Section 171.205, a physician may not knowingly perform or induce an abortion on a pregnant woman if the physician detected a fetal heartbeat for the unborn child as required by Section 171.203 or failed to perform a test to detect the fetal heartbeat. The law prohibits abortion of an unborn child once a heartbeat is detected. Now, Section 171.203 requires that standard medical practices be used to detect if a heartbeat is present. Now, if one is found, then abortion is generally prohibited. There is, however, an exception. Section 171.205, exception for medical emergency records. Section 171.203 and 171.204 do not apply if a physician believes a medical emergency exists that prevents compliance with this subchapter. So if a physician believes there is a medical emergency which prevents them from complying with the law, well, that's considered an exception, meaning if while treating a medical emergency, a doctor induces an abortion, they do not violate this law. But the third section is the one that I find most constitutionally interesting. Section 171.208. Civil liability for violating or aiding or abetting violation. A person other than an officer or employee of a state or local government entity in this state may bring a civil action against any person who, 1, performs or induces an abortion in violation of the subchapter, 2, knowingly engages in conduct that aids or abets the performance or inducement of an abortion, including paying for or reimbursing the cost of an abortion through insurance or otherwise, if the abortion is performed or induced in violation of this subchapter, regardless of whether the person knew or should have known that the abortion would be performed or induced in violation of this subchapter. Or 3, intends to engage in conduct described in subsections 1 or 2. So what's so interesting about this section of the law? Well, rather than making abortion a criminal offense, it makes it a civil one. In other words, rather than being sent to jail for performing an illegal abortion, a person pays damages. Also of interest, the person suing someone for performing illegal abortions cannot be a member of a state or local government. This means that anyone other than a government official can sue someone for performing an abortion in violation of this law. I believe the reason is for this to comply with the Supreme Court's opinion in Roe v. Wade, which states, a state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother without regard to pregnancy stage or without recognition of the other interests involved is violative of the Due Process Clause of the 14th Amendment. When the Supreme Court opined in Roe, they found that a law making it a crime to perform an abortion except to save the life of the mother violated the Due Process Clause of the 14th Amendment. In effect, the court said that such a limitation on abortion deprived the mother and or the doctor of the liberty to perform abortions without due process of law. Of course, the court did not appear to consider the question of depriving the child in the womb of their life without due process of law, but that's the problem with the Roe v. Wade precedent. The opinion goes on to say, for the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. For the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health. See, the court created this trimester scheme to determine when and how a state had an interest in regulating abortions. For the first trimester, the court believes the abortion decision is solely a medical one. After the first trimester, the court claimed that the states only had an interest in promoting the health of the mother. So when is it about the child in the womb? From the opinion, for the stage subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, regulate and even proscribe abortion, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. See, the Roe court used viability of the child to determine when the state had an interest in protecting, as the court put it, potentiality of human life. And this is where I think the court really messed up. Now understand, in 1972, when this case was argued and decided, medical imaging technology was not nearly as sophisticated as today. Meaning medical science in 1972 did not allow the level of detail we currently have when viewing inside the womb. Neither did it provide the information regarding the gestational development we have today. Still, the Declaration of Independence says, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. We were not created when we emerged from the womb, we were created in the womb. So the question of when the state has an interest in protecting life should not be based on viability, the ability to survive outside the womb, but on the detection of life, which is what the Texas bill does. By basing protection of the life based on life being detected, Texas fulfills its duty to protect the rights of everyone within its borders. Since the Roe opinion specifically states that a criminal abortion statute based solely on the life of the mother violated the Due Process Clause of the 14th Amendment, I believe the Texas legislature created a civil statute to avoid this legal hurdle. I also think they have opened up a couple of serious problems with their legislation, though. The first potential problem I see is the scope of who can sue for committing illegal abortions. As I noted previously, the law allows any person other than an officer or employee of a state or local government entity in this state may bring a civil action. This law places the burden of prosecution solely in the hands of the people of Texas. In other words, the state of Texas expects the people to bring the suit when the law is violated, rather than the state itself. Now, this isn't necessarily a problem, except for the second potential problem. The law states anyone other than a state or local government official can sue under this law. No other limitations are noted. So does that mean that I, as a citizen of Tennessee, can sue a doctor in Texas for performing and even intending to perform an abortion on a child without checking for a heartbeat? Does it matter whether or not I have a direct grievance against the doctor, other than the fact that the abortion of a living child is murder? See, I'm not a lawyer, but I believe it's standard practice for a court to consider a plaintiff's standing before proceeding with a civil case. Maybe the Texas legislature expects the courts to weed out the activist cases from those where someone is directly harmed. Unfortunately, that unleashes a potential nightmare of people and organizations filing suits against abortion providers in an attempt to sue them out of business. I don't find that just when gun control activists do it, and neither do I find it just when pro-life activists do it. That's why I think there's one part of the law that needs to be fixed, to define what grievance can be used to justify a lawsuit under this statute. Much has been said about how the courts have reacted to this lawsuit and why people should prevent the Texas law from going into effect. Sadly, very little of that talk has been based on the truth and facts of the case. What the Supreme Court was asked to do was to provide an injunction preventing the law from taking effect until the case had been decided by the courts. Now, this in itself is an extremely dangerous request since it effectively places the judiciary above the other branches of government, which is why Justice Alito noted in his opinion, to prevail in an application for a stay or an injunction, an applicant must carry the burden of making a strong showing that is likely to succeed on the merits, that it will be irreparably injured absent a stay, that the balance of equities favor it, and that a stay is consistent with the public interest. Now, Justice Alito went on to note that what the applicants are asking for is both novel and complex. For example, federal courts enjoy the power of enjoining individuals tasked with enforcing laws, not the laws themselves, according to California v. Texas. And it is unclear whether the named defendants in this lawsuit can or will seek to enforce the Texas law against the applicants in a manner that might permit our intervention. See, precedent allows the court to enjoin people, not the law. Now, since the defendant's name can seek to enforce the law because the law prohibits state or local government officials from filing suit, how can the court enjoin them? Oddly, the power of precedent that the applicants are using to file this suit is the very same one that is preventing the courts from issuing the injunction. It seems that we will all have to wait until the actual case is heard before we know whether the courts will find this Texas law appropriate or not. If there's one constant in politics today, it's that politicians lie. So no one should be surprised when the pro-abortion politicians came rushing to the bulwarks to defend their understanding of Roe v. Wade and the constitutional right to abortion. Now, President Biden said in a statement, "Today, Texas Law SB 8 went into effect. This extreme Texas law blatantly violates the constitutional right established under Roe v. Wade and upheld as precedent for nearly a half century." Funny how a law whose language appears to be specifically tailored not to violate Roe v. Wade is supposedly a blatant violation of that opinion. Even worse, though, is the constitutional lie President Biden is promoting. The Supreme Court of the United States cannot establish a constitutional right. That's not a power delegated to the United States, and since it's not prohibited to the states, only the states can establish a constitutionally protected right. In fact, what the court found was that before someone can be deprived of liberty to perform or receive an abortion, there must be due process. Furthermore, the Supreme Court does not have the legal authority to effectively create law by edict or opinion. The findings in the Roe v. Wade case legally impact only Roe and Wade. It is our judiciary's slavish devotion to precedent that gives power to the Roe decision, not the law or the Constitution. And President Biden went on to say, "And outrageously, it deputizes private citizens to bring lawsuits against anyone they believe has helped another person get an abortion, which might even include family members, healthcare workers, front desk staff at a healthcare clinic, or strangers with no connection to the individual." Now, to be fair, President Biden is correct in the potential scope of these lawsuits. As I've already noted, the fact that anyone other than government officials can sue anyone involved in the abortion that violates the statute, it can easily spiral into a nightmare of frivolous lawsuits. However, Joe Biden is far from the only person rising to combat this Texas law. He and Nancy Pelosi have promised to take up the Women's Health Care Protection Act of 2021 when the House returns from recess. Now, what is the purpose of this bill? Well, from the bill we read, it's to permit healthcare providers to provide abortion services without limitations or requirements that single out the provision of abortion services for restrictions that are more burdensome than those restrictions imposed on medically comparable procedures, do not significantly advance reproductive health or the safety of abortion services, and make abortion services more difficult to access. See, lost to the view of the pro-abortionist is the fact that abortion involves the health of two people, not just one. This bill and others like it focus on the health care of the woman while ignoring the health of the child in the womb. The bill promotes the unlimited access to abortion while ignoring the consequences of that access. They want no more regulation on abortion than a medically comparable procedure, yet ignore the fact that those procedures are prohibited from taking human life unless absolutely necessary. History has shown us that the pro-abortion activists are not interested in being regulated along with medically comparable procedures. They want as little regulation as possible, and it seems many among these activists are ready to do almost anything to get their way. For example, Alexandria Ocasio-Cortez tweeted, Republicans promised to overturn Roe v. Wade, and they have. Democrats can either abolish the filibuster and expand the court, or do nothing as millions of people's bodies, rights, and lives are sacrificed for the far-right minority rule. Now, while many Republican politicians have promised to overturn Roe, we all know how much we can trust a politician to keep their promises. Let's face it, what the Republicans claim is not so much that they will overturn Roe, but overturn what the Roe opinion has morphed into, an unrestricted right to abortion not supported by law. After decades of getting much of their agenda through the courts rather than through the legislature, is it any wonder the more progressive of the Democratic Party are willing to overturn the Senate rules, the filibuster, and to take over the courts to get their way? Does anyone else find it ironic that a party who's named after a democratic process uses such undemocratic methods to advance their agenda? See, there's a lot to unpack here, both in the legislation and the reaction to it. When does the government's duty to protect life begin? Is it when life is detected, when life is external, i.e. out of the womb? Or is it at some other arbitrary point? How should a state respond to an almost 50-year-old opinion that is not supported by the facts or science? And how should the American people treat the hyperbole on both sides of the argument? So as I've said so many times, this is why it's so important to go back to the original documents before we make up our minds on a subject. As for the law itself, I can easily see the justification for the heartbeat of the child being the delineation for when life must be protected. However, I do have concerns over the scope of who can sue. As for the Roe opinion, I wish more people would recognize it for what it is, a flawed opinion based on outdated science that considers only one side of the issue. Roe v. Wade is not law. To my knowledge, Congress has never passed a law legalizing abortion across the country. Then again, such a law would be unconstitutional, since not only has the Constitution not delegated such authority to the United States, the very idea of unlimited abortions violates the Due Process Clause of the Fifth Amendment. Now, while I don't expect it from what passes for our judicial class today, I would hope a rational and reasonable look at the law would guide the courts. I fully expect the advocates on both sides will use the Texas law and the court's decision to demagogue, vilify, and yes, fundraise, at least for the foreseeable future. I only hope that this article and this video has helped cut through some of the noise and the misdirection to help you find the truth. And isn't the truth what we should be looking for? I mean, that's really what I'm talking about, is going back to the original and finding the truth. The Roe v. Wade court did not find a constitutional right to abortion. It described abortion as your liberty or control over your body, your property. And that's an argument that we've used for everything from face masks to vaccines. The fact that they ignored the other party involved, the child in the womb, is really the flaw behind Roe v. Wade. And the hyperbole coming out of the political and pundit class, well, that's to be expected. The sacred cow of Roe, enshrined as protecting the right to abortion, has become dogma. It's a mantra repeated by the pro-abortion group. So I'm not surprised that they're afraid. Anything that might challenge their view of Roe v. Wade must be denounced and must be destroyed. If that means overturning the control of the Senate, if that means turning the courts into a political plaything, so be it. We must have our abortions. Which really says a lot about American society, doesn't it? So I fear one day that history will look at our society today much the way we look at the Holocaust in Germany. Millions of people dead because of a flawed understanding of what is life, when it begins, and when it should be protected. Now, as for the Texas law itself, I see a flaw, but I like the way they've started. My own, I like they base that on the heartbeat, because that's a sign of life. I'm even very intrigued by having it as a civil issue, not a criminal one. But I'm concerned as to the scope of who actually has a grievance. Maybe that's something that the Texas legislature will pick up in the near future. We don't know. I'm curious to see what the courts say, although I'm not really holding my breath. But I hope you now have a better understanding of the Texas SB 8 law and the controversy around it. Now, if you want more information, articles like this, go to constitutionstudy.com. I write an article every week. I post a video every week. You can ask a question. If you have something you want me to cover, go to the menu bar, click Ask a Question, and tell me what that is. I'll be more than happy to try and answer it, maybe even make it a video. But if you want to become a student, a scholar of the Constitution, that's what a scholar is, a student. Go to constitutionscholars.com. Join me there. It's a community of people that are reading and studying the Constitution and sharing their insights so we can all learn together. The whole idea of a Constitution study is a group of individuals getting together to read and study and understand. And the Scholars is a site where we can do that online. We don't have to worry about algorithms or shadow banning or even outright blockages. Basically, unless you're vulgar or criminal in your content, you can say whatever you want on that site. I allow it. I encourage vigorous debate, as long as it's not vulgar debate. So check it out, constitutionscholars.com. You can find more information there. If you want to be mentored, if you want to really engage as a scholar, then check out the apprentice program. That's your first stage of mentorship into becoming a true constitutional scholar. You'll get access to more reading material, more classes, more videos, but most of all, you'll be working with someone. I'll find a mentor for you to help you read and study, to help you become a better student of the Constitution, help teach you not just what the Constitution says, but how to study the Constitution. So check that out there. If you have any questions, contact me through that website. I'll be happy to answer them. But most of all, I hope that you take this video and the associated article and anything else you find on the Constitution study and share it freely. That's what it's there for. Read it, share it, use it, so that we can all make more rational decisions and not be driven by the emotional, hyper-partisan rhetoric that seems so common today. If you found this useful, hopefully you'll join me here again next time on the Constitution Study.
There's one thing you have to